When it comes to custody matters, by default, the courts look at custody matters in the sense of what's in the benefit of the child. What the courts attempt to do in a child custody hearing is to maintain the status quo. In my office, what we try to do is try to emulate a schedule that's going to benefit both parents and be beneficial for the child while they attempt to grow in a new modular structure. Every child custody or modification of support case is unique. It's based on a few things, such as the amount of parenting time you spend with a child, along with your financial capabilities. Other factors that play a role into child custody and visitation are domestic violence. Typically, if there's a domestic violence case in which the child's involved or the child witnessed any part of the abuse, that parent will typically get none or very little custody. In most cases, both parents want full custody. So essentially, my job is to help the client have reasonable expectations moving forward. There's typically very few scenarios when a parent gets 100% custody and doesn't have to pay any child support. Typically, when the writing's on the wall, it's going to be someplace in between. Custody is broken down into two parts. There's physical custody and there's legal custody. Physical custody typically has to do with who the child resides with. Legal custody has to do with important decision-making factors, such as obtaining medical records, making important decisions as far as school goes, traveling abroad. Joint custody is typically when both parents share both legal and physical custody. Sole custody is when one parent has both legal and physical custody over the individual. So the standard law requirements for child support in California take into effect what the earning capacity of the individual is, any special sorts of licenses that the individual may have who's paying support, and any other factors that might diminish their income. Those are all taken into consideration when determining child support. Along with that, you're looking at the earning capacity of the other parent who's going to be maintaining primary physical or legal custody, or who's going to be receiving any sort of support. After taking all of those factors into consideration, the court is going to find an amount that's suitable for child support. If you've missed out on child support payments, it's strongly advised that you seek legal counsel that's competent in these sort of matters to help you attain any missed payments along with interest to help supplement your child rearing costs. When you're trying to modify any sort of custody or visitation schedule, the courts typically want to defer to any sort of agreement between the parents. So what the courts do is they give an opportunity for mediation. Any sort of agreement that you could reach in mediation prior to a court hearing will be considered binding. If at any point you can't reach any sort of an agreement during mediation, the courts will intervene and create a plan that's going to be in the best interest of the child. If a child support or child custody agreement is not being followed, typically you're going to want to find a legal representative who's well versed in these matters, and you're going to file a case for enforcement. At this point, the courts will get involved and try to help enforce any sort of agreement that you may have had. There are some risks to representing yourselves in a child custody or modification action. We don't ever try to discourage anybody from representing themselves. However, whatever you do say is on the record. It can be used in any future proceedings, and in most cases, any request for modification or change is going to be set out at least a few months. So if you get any sort of determination that you don't agree with, you will have to stick with that for a few months before you could get anything changed or modified. A well-versed attorney is going to know all the legal intricacies of the judicial system and will be able to help you navigate through the processes. What makes us different in child custody and modification matters is that we take a custom approach by trying to understand our client's individual needs and making a plan that fits those specific goals and needs. My clients select me as their legal representative because I don't set unrealistic expectations. For most of my clients, it's refreshing enough that I answer the phone when they give a call. So I try to lay out the expectations for the case prior to my client signing up. I set realistic goals and I execute accordingly. Client communication is very important to us at the Bains Law offices. It's the backbone of our firm. I like to keep my clients informed because for most of my clients, this is their first time going through a legal matter. There's a lot of uncertainties, and a lot of the client's nervousness comes from not knowing what's going on. So if I'm able to maintain a sense of transparency with my clients, the less nervous they are throughout the court proceedings, and the smoother the whole process goes. I try to answer as many calls as I can personally. Of course, in many instances, I'm not able to. I return all my phone calls within 24 hours, and I like to return all emails or text messages within 12 hours. I would definitely consider myself a small firm. I'm born and bred in the Central Valley. All of my cases are in the Central Valley, so I understand a lot of the needs of the people that are around here. The advantages of having a small firm on your case is that I get to pick and choose the cases that I take. They're not assigned to me. So I could focus my efforts accordingly, and I could have my staff have a one-on-one experience with all of my clients. Once I take your case, my goal is to see it all the way through. The reason behind us having an initial consultation is to vet the case and to see if both parties, the attorney and the client, are a right fit for one another. Once we've established that, I will see your case till the end. As far as accomplishments goes, I have been recognized by numerous online organizations as being an outstanding attorney. Apart from that, I have been published in the San Joaquin Agricultural Law Journal for a piece that I did on the high-speed rail. I maintain a professional relationship with my clients. I try my best to not only understand the legal aspects of what they're going through, but also to understand on an emotional level what they're going through. And that helps me navigate, one, my client expectations, and then two, the judicial system. So for your initial consultation for child custody, essentially, I'd like to give a brief introduction about my background and our firm's culture, and I want to gain a little bit of insight as far as your particular case goes. That'll be a good vetting experience for both you as a client and me as an attorney to see if we're a right fit for one another. And if we are, we can move forward from there.